Get ready for one of Judge Boyd's most intense and unforgettable court days yet. From jaw-dropping excuses to emotional breakdowns, this courtroom is packed with real consequences, raw humanity, and unfiltered truth. Today, we witness defendants pleading for mercy, revealing shocking backstories, and facing sentences that will shake anyone watching to their core. You'll see a mother judged for her parenting, a man desperate for redemption, and someone who claims they're too sick to serve, only for Judge Boyd to clap back in a way that left the room completely stunned. Will justice show mercy, or slam the gavel down hard and final? Buckle up, because this is courtroom drama at its most gripping and real.
But I know I did put in an appeal. It's just that they never contacted me. I mean,
all right, so Mr. Beltran, I just need you to answer the questions that I'm asking of you, because I don't want you to say anything that you should not say, because your attorney is not here. We do not know where your attorney is. This hearing was scheduled at 9 a.m. and your attorney was supposed to be here at 9 a.m. Do you understand?
Yes, ma'am.
All right. So do you understand what an appeal is?
Yes.
All right. So do you wish to continue with your appeal?
Yes, ma'am.
All right. Now, I'm just going to ask you these questions. I already know the answer to them, but I must ask them because it's required.
Okay.
Do you have any type of savings account?
No, ma'am.
How long have you been in custody?
Like 2.5 years.
All right. And I will tell you, I'm not the judge who heard this. This was before I was elected to the bench. So there's another judge who heard this. So you've been in custody for 2.5 years?
Yeah, going on.
All right. Have you been able to obtain any type of funds?
No, ma'am. Just with what I could get here and there. Nothing much, really.
All right. Do you have any cash on hand?
No, ma'am. I'm incarcerated.
Okay. And again, I know the answers to these questions, but the record needs to be clear. Do you understand?
Yes, ma'am.
All right. My next question for you is, you said that you wish to continue with your appeal, and you told the court that you understand what an appeal means. A different appellate counsel be appointed to represent you.
Yes, ma'am.
All right. So, Mr. Beltran, what will end up happening, I will make sure that the appellate court has these findings, and we'll make sure that you're appointed a new appellate counsel.
Okay, thank you.
All right. Do you have any questions before I release you? We're off the record.
No, ma'am.
All right. We'll make sure that a new counsel is appointed to represent you for your appeal.
Okay, thank you.
All right. Thank you. Adolph Mendoza.
Yes, Your Honor.
Hello. So
Hello, good morning.
Good morning. Have you all conferred on a jury trial date?
Yes, Your Honor. Good morning. We did have the opportunity to confer. We believe that September 23rd, 2025 would work for both parties, Your Honor.
All right. Your jury trial date will be September 3rd. You'll need to.
I said 23rd. Sorry about that.
I'm sorry.
23rd is what we had proposed.
Okay. Your jury trial date will be September 23rd. Make sure that you appear in court. Do you have any questions, sir?
What time? At 9?
Yes,
in the
9
morning?
a.m. Yes.
Okay, ma'am. No, ma'am, no questions right now. I'm just waiting for my trial,
All right. We'll try to get you in as soon as possible. There are other cases that are set. And thank you so much for dressing appropriately for court, even though you're on Zoom.
Thank you, Your Honor.
All right.
Try to be
Thank you.
respectful.
All right. Have a great rest of your day.
Thank you, Your
You
Honor.
too, ma'am.
Excuse from Zoomland?
Yes.
Appreciate it. Thank you.
Gabriela Medellin.
She's one in the hospital, Judge.
Yes.
She said they're going to try to email me proof. I'll bring it back to the court.
All right. So I'll just wait for that.
Yeah.
All
It's
right.
supposed to be a plea for deferred, so we've been trying to get this done, but she's had serious health issues.
All right. Thank you. Christopher Medellin.
Judge, he is present.
All right. Let me.
That moment right there, classic Judge Boyd at her finest. She has zero patience for weak logic, flimsy excuses, or defenses that crumble instantly under pressure. When the defendant tried that reasoning, you could feel the judge's eyebrows rise before she even spoke a single word. And when she snapped back with, "That's not how any of this works," the entire courtroom energy shifted dramatically. This is where legal sharpness collides with moral clarity and firm authority. Would you risk trying the same argument in front of this judge? Or would you walk in ready to own your actions, decisions, and consequences?
In the court summary?
No objection from the state.
All right. So, Mr. Leal, you want to address the issues with his discharge?
Judge, I think my client, obviously he's an addict. He tried to conform with the regulation. I think it was just based on his refusal to take a drug test. That's why he was discharged.
But the report is saying a fake UA and also possession of drug paraphernalia inside a rehab center.
I don't know how that came about. My client was just telling me that he refused to take a drug test.
All right, but then they have the drug paraphernalia as well inside a rehab center.
That's bad.
So he's not trying very hard. All right, probation. Did he pay the fee for the testing of the drugs in the amount of $57? Is there anything you wish to say, Mr. Alvarez? Yes, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. No, state your name for the record. All right, so why are they saying you have drug paraphernalia inside a rehab center? Just 1 second.
Because when they found it, that's not even.
No, just 1 second.
What they found there wasn't even what I messed with. I used to mess with heroin. I was in drug court too.
Mm-hmm.
And I've been clean for like it wasn't even. There was somebody else who came out with that figuring. I don't know.
This moment is where legal reality hits like a heavy brick wall. Waiving the right to a trial isn't just a formality. It's the turning point of everything. The judge is crystal clear. If I don't follow the plea, you're still on the hook for the audience and outcome. This scene is nothing short of a legal masterclass in how plea bargains truly work behind the bench. It forces a hard question. If you were standing in this position, would you risk everything for a negotiated plea, or roll the dice and demand a full trial instead?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing? All right, why are you stealing? Why can't you stop stealing?
At the time, I just needed clothes at the time.
Well, did you go into the store wearing clothes?
Yes, ma'am.
So you had clothes. And then the person you were stealing with had $760 in her wallet. Last time I checked, that 2 Nike hoodies from Kohl's is not $760. Why didn't you all just pay for it?
Because that wasn't my money.
All right, so why are you stealing? I don't understand this. If you want something, you get a job and you work for it.
Yes, ma'am.
And this is not the first time you're stealing. That's why this is a state jail felony, because you stole twice before. You continue to steal. Did you have a job at this time?
No, ma'am.
So your thing is, I don't have a job, let me steal. What do you think would happen if everybody decided to steal? Like, I don't have a job, Let me go still. And I'm assuming the only reason why you're offered this is because you previously been in the hospital and that she's bedridden. That's why she's being offered this.
It is pretty much.
I mean, otherwise, this remaining with the deduction of the 800.
That includes the fine.
So how much are you able to pay monthly towards restitution?
I think you said last time 500, yeah. Be realistic.
250.
I don't think that gets us.
Mm-mm.
Is it 2
No,
years
it's
probation
good.
though, right?
No, it's 2 years probation. It'll
So
be
it's
set.
okay.
All right.
I was doing it by 12 months, but that's the
No.
underline.
All right, as previously stated, the court is finding you guilty. The court will set restitution at $1,104 payable to
Frost Bank.
it says Saints Peter and Paul.
We verified it, but we had that discussion before because Frost Bank covered the loss.
Okay,
And so I told you I was going to verify it with the state in between now, and I have with Mr. Pitluck, and it is Frost Bank.
all right, so there should be $1,140. That's the remaining balance to Frost Bank, and that's to be payable in installments. And you're sure about the $250 a month?
Yes, ma'am.
All right, installments of $250 per month. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be 365 days in the Bexar County Jail, suspended for 2 years. There's to be no contact with Saint Peter and Paul Catholic Church. What is your employment? What do you work? What do you do?
I'm a food service. I'm a manager at a restaurant.
Okay. And there's to be 100 hours of community service restitution. Do you have any children?
Yes, ma'am.
How many?
2,
What are the ages?
12 and 6.
All right, I'm going to order parenting classes. Once the parenting classes are completed, 50 of the hours will be deemed satisfied. And then I'm going to order the MRT course. And once that's completed, the remaining of the community service hours will be deemed satisfied. And there's going to be a field visit 1 time per month for 2 months. Probation, is there anything else?
Wilson County.
Okay.
That covers several counties, so he can report here, but the field visit can't be done.
Okay.
It's
All right. So how far is Wilson County from here? Help me. I'm sorry.
takes me about 30 minutes to get here.
All right.
Floresville.
Roughly.
So do they do a transfer to Wilson or no?
I mean, we can, but I mean, if you want the field visits.
All right. We can do a transfer to Wilson County.
He actually comes, his work.
This sentencing stands out as the most layered and carefully constructed of the entire day. Restitution to a bank, jail time suspended, probation ordered, and mandatory parenting classes included. It's not just punishment, it's a detailed roadmap for rebuilding. Judge Boyd crafts every term like she's sketching out a second chance with firm boundaries and lasting structure. Notice how she still asks thoughtful questions about the defendant's job, her kids, and her ability to pay. This isn't just about enforcing the law, it's about restoring balance and building accountability. If you were in her shoes, would you consider this sentence too harsh, too lenient, or exactly right in every sense?
To provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. White, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 180 days in the state jail facility, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
All right, state any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
No objections.
Did you review the waiver and state you may be excused? Did you review the waiver and stipulations with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you.
This one was heavy, deeply heavy. When the defendant opened up about their mental health struggles, addiction issues, and simply wanting stability in life, it was raw, painful, and heartbreaking. Judge Boyd didn't dismiss it or brush it aside. She paused, reflected, and processed it carefully. This moment shows the deeply human side of courtroom justice. It's not just about verdicts or cold rulings. It's about whether the justice system can truly offer a meaningful path forward. But the question lingers: how many chances should someone get? And what happens if they've already run out of borrowed time completely?
You understand? And I understand that sometimes when people have mental health issues and they're not on their mental health medication, then usually they resort to using controlled substance, and those controlled substances are against the law. You understand? And I've read the police report, and the way you're presenting now is not the way you presented in the police report. So that tells me that when you're on your medications, you're fine. And I understand that sometimes medications, they have side effects, and then you don't want to take them. Or either sometimes you say, I'm feeling great, so why am I on meds? But for you, you're going to have to stay on your medications. If there are any side effects, you're going to have to let the doctor know, because otherwise, more likely than not, you'll end up back before a criminal judge, and you don't want that.
Yes, ma'am.
Okay. All right. This is the court is going to do. The court is going to find you guilty, sentence you to 180 days in the state jail facility, give you credit for any time served, and I'll request the therapeutic community. It doesn't increase the time that you're in custody, but it's just a program that's designed to help you with your mental health, to help you with your drug addictions. Do you understand? So you will serve no more than 180 days, but you're receiving credit for any time that you've already been in custody on this offense. Do you understand? Is there anything you don't understand about my sentence? All right. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you sign it?
Yes,
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So here's the thing. When you are released from the state jail facility, if for some reason you can't find a mental health facility, or you don't remember this, because sometimes people go and they forget, right? you can come back to this court and I will pick up the phone and call a place for you, okay?
Yes, ma'am.
All right, any questions about anything? All right, good luck to you, okay?
Not suggesting necessarily that it should be, but anyway, he would like resources to get back on his feet, find a place to live permanently, correct?
Correct.
All right, so Mr. Gonzalez, I want you to know that I've heard your plea. I've heard your attorney's argument. And I want you to know where I'm coming from, right? So you were placed on probation, and I understand the mental health issues. Normally, when you have a harassment of a public servant, there's usually some mental health issues involved.
Yes.
I always find it concerning when people are in mental health facilities and they assault someone, then we come back here. But here's my, yes.
Between me and the officer, it was a miscommunication.
Oh, no. So let me explain something to you.
I
No,
was
no, no.
gonna let you know what happened because I feel like if he had spoke to me differently, I wouldn't have did what I did because he had called me crazy and I thought he was disrespecting me. So I disrespected him back. I spit on him on his leg. He wiped it back
Well, here's
off
the
onto
thing.
me.
But
And
here-
then later he told me that the reason why he had said what he said, because he said, you need to go to a medical unit, you need to go to a mental unit, don't you? He said it was miscommunication. I wasn't trying to be rude and call you crazy. I was trying to make sure that I placed you in the right place you needed to go.
Here's
And I
the
wish
thing,
that I
Mr.
understood that when I had heard it.
But I
It
understand.
was
But
just
here's,
like a quick reaction and I shouldn't have
but
did
here's
it.
the thing, Mr. Gonzalez.
Yeah,
That ship has sailed
yeah, for
as
sure.
far as while you're on probation, or the reason you're on probation, because you've been on probation, for a while, since 2020. And I want you to know where I'm coming from. I always want to give people conditions that are helpful to them. I see people as individuals, and I try to give them conditions that is for that specific individual.
Okay.
So if that person has a drug problem, I try to give them drug treatment. If that person has mental health issues, I try to do that for them. But the key thing about all of that is you can't help somebody who doesn't want to help themselves. You can't help somebody who's not showing up, right? And so you were here on August 5th, 2020 for a motion to revoke. And that was a violation of condition number 5, which is not reporting. So what ended up happening is there was a jail sanction, and then you were continued. Then May 17th of 2021, another number 5, failure to report. Your conditions were altered and amended to include a MIC evaluation to address whatever mental health issues you may be having. And then on August 22nd, 2022, you had a violation of condition number 22. And again, tried to help you with that by doing a TAP evaluation in custody because there were some drug issues that maybe had not been previously addressed. And there was a referral for the Center for Healthcare Services. Then you come back on March 2nd, 2023, violation number 5, not reporting. It was denied, and both parties wanted, and probation agreed, and the state agreed. They wanted you to go to ISF2 and have you placed back on the mental health caseload. Then, prior to all of this, let me see, not prior, but on March 26, 2024, you had a violation of condition number 1. And then I tried to have you referred to felony drug court, and you extended for 2 years. So now you are here today on a violation of condition number 5. There is nothing else that I feel that can be accomplished for you by keeping you on probation. I don't think you're a good candidate for probation. So what I'm going to do is I'm going to revoke. I'm going to sentence you to 5 years in the prison, give you credit for any time served. There'll be credit for any successful.
This moment felt like a courtroom documentary condensed into one single powerful speech. The judge didn't just scold the defendant. She documented the entire journey, every violation, every opportunity, every second chance, and every reset until her patience had finally run completely out. This is exactly why people follow Judge Boyd's cases. She doesn't merely deliver rulings, she delivers unfiltered truth and accountability. And when she said, You can't help someone who doesn't even show up. You felt that line cut through the silence like a knife. Do you think she made the right call here, cutting off probation for good this time?
$500 fine, time, and money to run concurrently. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. You have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. When you're released from custody, if for some reason you can't find any location to help you with your mental health, if you come back here and I'm still here, I'll make sure that a placement is found for you.
I'm sorry, I misspoke. I missed the new number 1.
Yes. Oh, no, that's fine. The docket sheet, because they're doing Odyssey, sometimes it's misplaced. Yes.
He has maybe like 304 days credit in county and 300 more or less days from the programs he's been in.
All right. Just check with the clerks and they'll make sure he receives appropriate time.
Okay.
All right. Thank you.
And then the hammer drops. 5 full years in prison. A life-changing decision that did not come lightly at all. After reviewing every warning, every program, and every single second chance, the judge concluded there were no more meaningful options left. For some viewers, this outcome may feel cold and unforgiving. For others, it will feel firm, fair, and absolutely necessary. The real question remains, was this true justice being served? Or was it too little and far too late for real change to ever happen?
If you tell me you don't have a drug issue, I'm going to notate that you said you didn't have a drug issue, which would mean you shouldn't be testing positive, because I'm going to order that they drug test you.
Okay.
And if you come up positive, you know what's going to end up happening?
Mhm.
That's 100% on you, because you told me that you don't have a problem.
Okay, I don't have a problem.
All right. So you don't need any type of drug treatment?
No.
All right. I'm going to notate that you said that you don't have a drug problem and you don't need drug treatment.
Okay.
All right. That's a $1,500 fine. It's going to be probated. 2 years deferred adjudication. I'm going to want the UA hotline for 6 months. Then there'll be regular random UAs after that. Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person. 120 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's to be no contact with the following locations. Proof of employment within 30 days. No employment as a home health care provider or with minors. And there's to be no residing with minors. Take in consideration 2025 PF 28602. Probation, is there anything else?
Judge, tell me the code that her cargo after.
It's 78220. All right, is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
What an absolutely incredible docket. In under 30 minutes, we witnessed the full and complete range of courtroom justice. Pleas, empathy, frustration, and finally the hardest of sentences. From suspended jail time to 5 long years behind bars, Judge Boyd handled every single case with clarity, precision, and zero hesitation. Whether she was offering parenting classes, granting probation, or calling out false narratives, she made sure each case ended with decisive direction. One thing is certain: no one leaves her courtroom the same person they walked in as. If you found this case as shocking, gripping, and unforgettable as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns that tell it all.